Ladies and gentlemen, the second session of today's event on open innovation is really going to be looking at open access, open innovation, open licensing in some of the cultural dimensions. So QUT in particular is very much focused upon the creative industries and design and architecture, and we have an array of speakers who will be tackling some of those dimensions of the topic. Our first speaker, Dr. Joanne Gray, is based at QUT at the Digital Media Research Centre and the Creative Industries Faculty. Her thesis has been turned into a book and will be out in the beginning of 2020. I've had a sneak preview of the work, and it's a very sophisticated and concentrated analysis of Google and all the various copyright issues that the search engine has faced. Dr. Joanne Gray will be discussing the intergenerational cultural implications of automated regulatory technologies in digital media environments. Dr. Gray.
Thank you, Professor Rimmer. So the intergenerational cultural implications of automated regulatory technologies in digital media environments is an incredibly boring title. And so just to one-up Professor Rimmer, I'm actually going to play some music for you.
Did you notice, side by side? 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 Did you notice, side by side?
For the world that's wanna love somebody, love somebody. With all my strength, I wanna hurt nobody, hurt nobody. For the world that's wanna love somebody, love somebody. With all my strength, I wanna hurt nobody, hurt nobody. There are gods in here, there are gods in here. There are gods in here, there are gods in here. Young honey, young honey, young honey, baby. Young honey, young honey, young honey, baby. Before the night ends with my best behavior, best behavior. With all my strength, be on my best behavior, Before the night ends with my best behavior, best behavior. With all my strength, be on my best behavior, There are gods in here, there are gods in here. There are gods in here, there are gods in here.
Did you notice, side by side?
Okay, so that is the artist Caitlin McGregor, and I worked with her in my career as a artist manager, and I began to work with her when she had just released this record independently, and included this song Baby Teeth. She'd released it in Australia, and she started to get a lot of traction in film and TV sync, so people using her works for film and television shows and commercials. And so I started working with her, and we thought she had potential to get similar sort of revenue streams in the US. So we took her over to the US, and we got an offer by a what's called a sync house, people that specialize in that sort of work. And we eventually, got the contract, and it was very it was a big achievement. But we then, at this point, when we have the contract and we'd already sunk some of her music had already been synced, we realised she has in her songs, they're layered with found sounds and different recordings, and in particular the song I played you, Baby Teeth, you may or may not have picked up, there's someone saying, "Did you notice side by side?" And that's from a 1940s medical record. And so even though it's only used 1.5 seconds 8 times throughout, and you listened, it's an element of the song, but it's not the key component. Anyway, we won't go into that too much. But so she's used this record, and she's just found it in, I think, at her parents' house, and used it without permission. And we think we're going into the US, the litigious US, and so we get a copyright lawyer to do some research to try and clear the song before we sign this contract with a sync house. The lawyer couldn't find the owner of the works, and eventually we had to make the decision whether we would sign the contract saying that no, there are no other copyright claims to this work. And we just went ahead and didn't get permission, and we signed the contract. We essentially took an informed risk that we didn't think we were at risk of litigation. So I've been starting to think about what is in store for Caitlin McGregor. Her performer name's Caitlin Park. Of the future in a world where we have these automated rights clearance systems all over the internet. So we know from research that a clearance culture inhibits cultural production, creativity. Clearance culture is this ideology that anything that could be cleared should be cleared, that you have to get permission from anything that might possibly, to use anything that could possibly be litigated. That's the clearance culture. And a lot of great research and scholarship has looked at this in terms of its impact on documentary filmmaking. So we know from research that the creation of documentaries is inhibited when filmmakers want to use some sort of cultural artifact and they don't know who the rights holders are, and even if they do, often the rights holders don't respond. So they can't get permission, and because they have to assign these agreements that say that there's no risk associated with copyright, they either don't get disseminated, or they change their work, or they don't do what they were planning to do. And this is thoroughly researched by excellent scholars like Professor Yazi and Patricia Ofterhide, and also Kylie Papalato and Nick Souza here at QUT. And so it's particularly problematic when works are decades old. It's very difficult to clear works because copyright is messy and it gets assigned in all different directions, and people die, and it can be very difficult to track them down or figure out who owns what and which aspects need to be cleared. So there's that context. And then there's also what we see happening is increasingly with automated regulatory systems that automatically clear rights are being applied or being asked to be implemented over in significant portions of the internet. And the most advanced version we have of this is Content ID on YouTube. So essentially, YouTube has this vast database of audio and visual content that has predetermined permissions set against it. So you upload something to YouTube and it's scanned against that database, and then the copyright owner's decisions are applied to that video that's uploaded automatically. And I've done a lot of research here at QUT and in my thesis on Content ID, and so have others, and we know quite well, confidently, that it is very susceptible to error, and that it lacks contextual sensitivity, and that even when people provide permission for something, when it can get stuck in what's called the YouTube vortex, where you can't give permission. And we know that it blocks all sorts of content beyond what we would consider copyright subject matter. So a cat purring, white noise, different ringtones and things have all been blocked by Content ID. Yet, policymakers are increasingly calling for this sort of technology to be deployed all across the internet, and the recent EU copyright directive is the most recent example of that. It basically incentivizes or requires that platforms implement upload filters to filter all types of content across all different platforms. So there's this is what's been percolating in my mind, and I've sort of started to think beyond, in my research so far, I've sort of looked at the function of these systems and their legal status, but then just reflecting back on my work in the music industry, I've started to think, well, what impact are these systems going to have on artists and creators in 50 years' time? I think there's an augmented sort of clearance culture happening. I wonder if we're moving towards a future where we still have these problems of orphaned works, and that is, difficulty in finding rights holders and then obtaining permission even if you know who owned it. But with this added layer, this technical layer of restriction that prevents dissemination based on the decisions of rights holders from generations ago. So essentially, I wonder if we're moving towards this future where there's actually no option for not getting permission, and there's no option for informed risk-taking like we took with Caitlin's work. I don't know exactly what we should do, but looking at what researchers in looking at the clearance culture have suggested, and then sort of thinking about how they apply in automated systems, I think probably we need to start talking about and researching how clearance processes, particularly for orphaned works, can be built into automated systems. But also something I come back to all the time in my work is that we need to focus the policy debate on the long-term interest of creators and not the established industries. Sorry, this has been quicker than I thought, but this is my book on Google and some references, but thank you. Okay. Professor Roman's allowing me to give a plug of my book. For my PhD thesis, I looked at Google's influence on copyright law, and looked at their some of the case law, but then also looking at their practices and a lot of what they're doing and how they've shifted from being sort of this corporate white knight advocating for digital rights and rights to use works, public rights, to more partnering with rights holders and having a much more complex relationship with copyright law than they did, and looking at what that means for the future and the future directions, and particularly around AI and automated systems. And that'll be out through Oxford University Press in January next year. Thank you.